And now I think we can proceed, but let me make a couple of announcements. And I will show you where you can find the forum materials presentations in the language that is most comfortable for you. So we have materials available in both English and Ukrainian. So let me share my screen because we did it yesterday already. We understand that every day we have more people or different people from yesterday. So there's Padlet here where you can find all the forum materials. They're going to be available even after the forum. So this is available for you forever. So you can actually check all the information from all the days about all the speakers, their background information. You can see it by chapters. And if you scroll from left to the right, you can see the agenda as well in both languages. You go, for instance, if you want today's agenda and today's materials, you go to July 26. You can find all the speakers over here. All this information is available in this strict order, fully according to the agenda. If you scroll to the right, you can find all the presentations in both Ukrainian and English. As well, you can find presentations and other materials in both languages, like I said. And also there are useful materials in the far end to the right, where we uploaded additional documents, some useful information delivered by the speakers. So for your convenience, please use that. The speakers will be sharing their presentations and intervening in their own language, and there is interpretation available. You can also follow the materials translated in Ukrainian. So please welcome everybody. We can now start our today's forum, and it is my pleasure to give the floor to Oleksandra Paduchak, who is a professional at the Mediation Center of the Ukrainian National Office for Intellectual Property. This is the Ukraine's IPO. Can't wait for this very interesting and fabulous panel discussion. And we're going to discover and try to investigate whether mediation is actually possible in intellectual property disputes. Over to you, Oleksandra. Good morning, dear participants of the VIII International Forum, Mediation and Law. Good morning, dear speakers. We want to thank you so much, and this is a great privilege that we have you here on our panel discussion on the topic of mediation in intellectual property disputes, prospects for the right holders, business, and government. Thank you for entrusting me this moderation function. Our panel discussion will focus on the importance of mediation's capacity in IPR, and it is important to have this international best practice shared and consider some of the practical cases and success stories. And for this, we try to put together practitioners, genuine professionals with a lot of experience in mediation. Today, we have representatives of the WIPO. This is Isha Singh, who's legal case manager and at the IP disputes section. Lidia Levitska, legal case manager at the Internet Dispute Resolution section from WIPO. We have European Union representatives from the EU IPO, Marisol Ortiz-Moreno. She's an IP lawyer, member of the ADR service at the European Union Intellectual Property Office, EU IPO. We also have Oleksandra Krokor, IP specialized lawyer. We also have Jeremy Lack, Swiss and US and the United Kingdom's lawyer specializing in international IP disputes and appropriate dispute resolution, ADR. Ulrika Grubovska, head of Mediation Center from the Ukraine's IP office, and Bogdana Hemenko, a mediator and attorney at law from Ukraine. We have 2 hours for the discussion. Seems to be a lot, but it's not, because there are so many guest speakers with so much valuable experience, and this is a really short session given their vast experience and expertise. So the timing for every intervention and presentation will be 15 minutes, please. After this, we're going to have short time for discussion, maybe just consider 1 or 2 questions And before we kick off, I would like to also tell you a bit about our audience so that you understand who we have here. And for this purpose, we suggest a short integrated Zoom call so that you know a bit about our audience today. On your screens, you're supposed to see questions. Dear audience, you just answer between yes and no, and then we're going to gradually get acquainted with you, dear all. I cannot see the poll in English, so I'm going to try to ask the interpreters to translate all those questions so that our international participants understand what it is all about. But I cannot see the poll myself. I would dearly translate it.
Зрозуміло. Я буду тоді, давайте так, я тоді буду голосом
Okay,
озвучувати.
I'm going to
Чи був у
be
вас досвід? Перше запитання.
voicing the
Був у
questions.
вас
Question
досвід
number one. Have you ever had
використання
experience
для
of
вирішення
using
спорів
mediation to
власності?
resolve
Будь
IPR
ласка,
disputes?
перший варіант – це так, другий варіант – це ні.
The first option is yes, the second one is
Це
no.
щодо першого питання.
Obviously,
Чи
that's
був у
the
вас
question
досвід
number
використання
one.
медіації для
Have you ever
вирішення
used mediation to
спорів
resolve
власності?
intellectual property disputes?
Друге,
Yes or no? Number
чи
two,
підтримуєте ідею
do you support the
обов'язкової
idea of
спеціалізації
mandatory
медіаторів у
specialization for
спорах з
mediators
інтелектуальної
in
власності?
IP
Перший
disputes?
варіант – так.
First option,
Другий
yes.
варіант
The second option is no.
Чи під...
Do
Друге
you
запитання.
support
Чи
the idea of
підтримуєте
specialized mediators
обов'язкової
in
спеціалізації для
IP
медіаторів
disputes?
у спорах з інтелектуальної власності?
Yes or no?
Третє запитання.
Question
Чи
number
є
three.
доцільним запровадження
Is it reasonable
обов'язкової судової
to
процедури
introduce
у
mandatory
спорах з
judicial
інтелектуальної
procedure
власності?
in IP disputes?
Обов'язкової досудової
Mandatory,
процедури.
oh, sorry,
Це я не так
free
прочитала.
trial. Sorry, that was my
Чи
mistake in
є
reading.
доцільним запровадження
Is it reasonable to
обов'язкової
implement
досудової
mandatory
процедури у спорах
pre-trial
з
procedure in
інтелектуальної
IP
власності? Перший
disputes?
варіант так, другий варіант ні.
Yes or no?
Бачимо, що всі
We
відповідають.
can see that
Дякую,
many
що
people are answering.
відповідаєте.
Thank you very much
Вже
for
понад 100 учасників
answering the
відповіли.
questions. Over 100 participants already answered.
Це чудово.
That's brilliant.
Поки наші учасники
And
відповідають,
while
я
our
вже
participants
хочу, щоб ми
keep
розпочинали,
answering,
оскільки в
I
нас
would like to
обмежений
actually
часом.
kickstart
Нагадати,
today's panel
Чи
discussion
можна
because we're limited in
продемонструвати
time.
результати одразу?
Actually, let us demonstrate
Чудово.
the findings, the results, actually.
Подивимося на результати
Let us
опитування.
take a look at what we have here. So to the first question, have you had any experience in IPR disputes through mediation? 93% said
Наших
no.
учасників не мали досвід використання
They've never had any
медіації для
experience
вирішення
of
спорів з інтелектуальної
resorting to
власності.
mediation for IP disputes.
82%
Now,
у нас підтримують
82% support the idea of
обов'язкової
mandatory
спеціалізації
specialized
спорів з
mediators in
інтелектуальної
IP
власності.
disputes
І,
who have special training, obviously. And
78%
78% versus 22 believe that it's quite reasonable to introduce a mandatory pre-trial procedure in IP disputes. That's the result that we currently have. Let us keep them in mind. And I think we're going to be referring to these results in the course of our today's discussion. So let me begin then and hand the floor over to Isha Singh. Singh, she is a legal case manager in IP dispute section at WIPO. So this is the World Intellectual Property Organization. She specializes in pharmaceutical, medical, and biological disputes. She has dual qualification of an attorney and the Master of Law of Georgetown University. Part of her expertise is IP through mediation in medications and food products. She's also working with commercial contracts. She's going to tell us about WIPO mediation of IP disputes, and she's going to tell us about the current trends, and also deliver a couple of practical cases to illustrate how mediation successfully applies by different parties to resolve the number of disputes in IP with at minimum cost, time, and money. Thank you. Isha, the floor is yours.
Thank you, Oleksandra, and all of the organizers for having us at this panel, and also to all the distinguished speakers for their time and expertise. And thanks again, all of you, for tuning into this webinar. As mentioned, I'm a legal case manager at the WIPO Arbitration and Mediation Center, and I will be providing you a short update on the WIPO Center and some general trends in the area of IP and commercial disputes, and also highlighting the importance or the use of mediation in resolving IP disputes. So as most of you might know, WIPO Arbitration and Mediation Center, we've been around for quite some time, since October 1994, with offices in Geneva and Singapore. We're part of the IP and innovations ecosystem sector at WIPO. And the role of the WIPO Center is essentially assisting parties in resolving commercial and IP disputes outside the courts through different alternative dispute resolution mechanisms. Being part of a UN agency, the center offers international neutrality as a forum, as well as strong specialization in IP and technology disputes, where we maintain a list of more than 2,000 external non-WIPO staff experts in the area of disputes and IP that the parties are free to choose from for the resolution of their disputes. Next slide, please. Now, most of you might not need this introduction, but just for practical purposes, this slide provides an overview of the types of ADR procedures provided, or options provided by the WIPO Center. The first one being mediation, the topic of today's webinar. So mediation is an informal process where both parties consent to referring a dispute to mediation, and they select an external neutral, an impartial neutral called the mediator, who assists the parties in reaching a settlement of their dispute. And the mediator essentially just acts as a facilitator in facilitating dispute resolution, but the mediator, however, cannot impose a decision on either of the parties. It's a fairly flexible process, a very party-led process, and the settlement agreement that is concluded between the parties it carries the force of a contract and can be enforced in most jurisdictions as a contract. Arbitration being the second option, the center provides both standard and expedited forms of arbitrations. Compared to mediation, this is a slightly more formal process. Parties are free to choose they have a fair amount of flexibility compared to court litigation, even in arbitration. However, in this, the dispute is adjudicated by a tribunal of arbitrators or a sole arbitrator, and they issue a binding and a final decision, which is essentially binding on both parties and enforced internationally. Now, WIPO expert determination is a third option that parties are free to use as part of mediation or arbitration, or independently. It is essentially an option that the parties may use to refer a specific matter, for instance, a scientific or a technical question, for instance, calculation of damages, or any other specific question to a panel of experts or a single expert. And they can choose whether this determination that will be reached by the expert may be binding or not. So this can, again, be used on a standalone basis, or in the context of a broader dispute, or even during negotiating a contract or an agreement. Next slide, please. This slide provides an overview of the role that we here at the WIPO Center play in case administration. So the role of the center is essentially providing procedural assistance right from the very outset of the moment we receive a dispute request at the center. So from submitting the dispute to ADR, drafting ADR clauses, submission agreements, to the selection and appointment of neutrals. And I think it's also worth mentioning here, I haven't included it in the slide, but through the WIPO Good Officer Services, the center provides complementary procedural guidance to parties who are contemplating submitting a dispute to WIPO ADR. And we have seen that this complementary service has essentially benefited a lot of SMEs and startups to have filed good officers requests, which have later converted into WIPO mediations and have led to a successful and cost-effective resolution of their dispute. As part of its case administration services, the center also provides a series of online case management tools, which have been very, very useful, especially in the recent years since COVID happened. And we were seeing that a large chunk of our proceedings are still happening online. So parties have benefited from these online case administering tools especially. And in the case, in administering of such procedures, the center draws on its list of neutrals, comprising highly specialized arbitrators and mediators with expertise covering almost the entire legal and technical spectrum of intellectual property, and also includes a sublist of experts specialized in different sectors such as domain names, life sciences, FRAND and standard essential patents, among other areas. Next slide, please. So why really mediate intellectual property disputes? I think one key benefit is the decreased expense, of course. IP cases can become very costly very quickly. And this in large part could be due to IPs being protected in different jurisdictions, also leading to multiple court litigations. The discovery process involved in litigations can be really lengthy. IP cases also often need testimony from experts to help them build the case. So this can all take a great deal of time and money. Another advantage is flexibility. So mediation is generally a much more flexible process when compared to traditional litigation or arbitration. During mediation, the parties can agree to almost any resolution, except, of course, those that would violate the law or public policy. And parties have broad autonomy and control over the mediation process, such as the mediation schedule, choice of experts, and the process may include a discussion of potential resolutions during the initial phases of the mediation or at any stage, essentially. And parties are also free to focus these discussions directly on their business interests, thereby excluding or leaving out legalities also. And IP collaborations are also ordinarily long-term. So mediation can be an effective tool in resolving disputes occurring over the course of these collaborations without disrupting the business relationships between these parties and in maintaining overall trust. So that's another added benefit of mediation. Additional benefits could also include efficiency, for instance, by choosing a neutral that has specialized knowledge of relevant law or the technology at issue. Parties can cut on a lot of time and cost. And this, again, when compared to arbitration, where parties need to choose 3 arbitrators, the cost can exemplify very easily. And then confidentiality is also another benefit. So the increased level of confidentiality that comes with the mediation process is also quite beneficial, as the parties can get into the details of the dispute without the fear of information revealed during the process becoming public knowledge. Next slide, please. Now, this slide provides an overview of the WIPO Center's caseload. And as you can see, the largest portion of all cases related to copyrights, trademarks, followed by patents and IT disputes. And traditionally, in WIPO cases, we have seen parties coming in from Europe and North America. But more recently, we see quite a strong role in cases involving now parties from Asia as well. On the sources of our cases, traditionally, most of our cases were based on contract clauses in agreements between parties, but in the last few years, we've seen an increasing number of cases being referred to WIPO mediation or arbitration after the dispute has arisen without any prior agreement between the parties. For example, infringement situations. And most of our cases traditionally and still are international, with parties based in different jurisdictions or rights protected in different jurisdictions. We offer case administration services in a number of languages, as you can see. And I think something worth flagging here is the average settlement rate in WIPO cases. It has been very good, with more than 70% WIPO mediation cases settling, and almost 1 in 3 or 33% of arbitration cases settle even before an arbitral award is rendered. Of course, the big trend in the last few years has been the move to an online conduct of all our proceedings. And even now, as I mentioned, 95% of our proceedings are conducted entirely online. And there's been quite a growth in our caseload, with almost 24% in 2023, and we continue to see a bigger growth this year. Next slide, please. Now, the WIPO Center has concluded several collaborations with national IP offices and courts across, I think, 80 plus countries, including Ukraine. Following the conclusion of an MOU with the Ministry of Economic Development and Trade of Ukraine in 2018, the WIPO Center has been engaging with Ukrainian stakeholders on IP and ADR and domain name dispute resolution in collaboration with the ministry, the IP office, ADR associations, and Ukrainian law firms. For instance, in 2021, we conducted a joint webinar to raise awareness on IP and ADR. So this slide is just to provide an overview that this is also something that we do. We offer a variety of services tailored to specific jurisdictions also, even though the WIPO rules are largely applicable to almost any jurisdiction. Next slide, please. So more recently, we're seeing an increasing use of WIPO ADR clauses in international agreements being concluded by patent pools, product development organizations such as the Medicine Patents Pool, FIND, the Global Alliance for Diagnostics. And some of these agreements included a WIPO mediation clause. For instance, I've highlighted this example of a licensing agreement between Pfizer and MPP for a COVID-19 drug, and the sublicense also includes Ukrainian manufacturers. So please feel free to have a look at this WIPO mediation clause. Next slide, please. So this is just one additional thing that I wanted to highlight here. Typically, ADR or mediation, arbitration, any form of ADR is a consensual process. So you need the consent of both parties to refer a dispute to WIPO mediation. But this is a relatively new provision that we added in 2016 to our rules, Article 4 of the WIPO mediation rules. And this applies to an instance where one party wishes to submit a dispute to mediation, but no prior mediation agreement has been concluded. So under the WIPO mediation rules, a party may submit a unilateral request for mediation to the WIPO Center, and the WIPO Center may then assist parties in considering that request, or upon request, even appoint an expert to provide such assistance. And if the other party agrees, the center then proceeds with the appointment of the mediator. Otherwise, the mediation stands terminated. So this is just that an example of the form that either of the parties can fill out and share with the WIPO Center. And it includes a description of the parties, a very short, brief description of the dispute. And then the center can assist the other party in considering this request for mediation. Next slide, please. Now, I'll just take the next couple of minutes to go over some anonymized case examples of mediation being used in the context of IP cases, and this specific case.
Пані Іша, можна я вас просто вибачаю, що перебиваю, обмежу
I apologize for interrupting. If you could please finish within 2 minutes time, could you?
Yes, absolutely. So I'll just share with you two small case examples of where mediation has led to a successful resolution of IP disputes. This very instance is a case resulting from a collaboration with the IP Office of Singapore, and it involved a Thai individual and a US company in the area of sports tech. And these trademarks, this was a trademark opposition dispute, and it involved trademarks being registered in different countries, as you can see, and the parties agreed to submit and unify all of these trademark proceedings into a consolidated WIPO mediation. The center thereby appointed a Singaporean mediator experienced in the area of trademarks. And after a single day mediation session in Singapore, the parties were able to continue direct negotiations, and they reached a settlement within 4 months since the commencement of this mediation. So this is just one such instance where you can see that the parties have limited their cost manifolds by just referring a trademark dispute to WIPO mediation. And I think the costs were also somewhere between $10,000 in this case, which was fairly low compared to an arbitration or court proceedings, which would occur in different jurisdictions. Now, I will just fast forward to the second last slide, which is a WIPO deal mediation case example of a pharma dispute. So this was a pharma patent license that a European university and a European pharma company had been negotiating for almost 3 years. So in principle, they agreed to conclude this license, but they could not agree on the terms of this license. So finally, the parties gave up after 3 years of failed negotiations, and they referred the dispute to WIPO mediation by signing a submission agreement. The WIPO Center then appointed a mediator with demonstrated expertise in the area of pharmaceuticals and life sciences. And after just a single day session with the mediator, who allowed the parties to identify the issues and also sort of deepen their understanding of the legalities surrounding their proposed contract. On the basis of this, the parties concluded direct negotiations amongst themselves and reached a settlement agreement. So this is just another example of how mediation can not only help in the resolution of disputes after the contract has been concluded, but also during the negotiations phase. And yeah, with that, I would like to end my presentation. Here's just an overview of some of the additional resources that you guys might be interested in reviewing. And yeah, with that, I hand it back to Oleksandra.
Дякую, пані Іша, за змістовну презентацію, цікаву статистику.
Thank you, Isha, for your interesting presentation and interesting statistics. I already have some raised hands, and I would like to remind our colleagues, audience, please write your questions in the chat. And now I'd like to give the floor to our next speaker, Lidia Levitska. She is a manager on internet cases, and today Lidia will talk about dispute settlements regarding domains in intellectual property. Lidia, the floor is yours. Please stick to the timetable.
Thank you so much, Oleksandra, for your kind presentation. And I will share my screen in order everyone has access to presentation. 1 second. Can you see it?
Так.
Lovely. So it's a great pleasure for me to participate in this International Forum on Mediation and Law. And so topic of my presentation is domain name dispute resolution at WIPO, general overview. So I will start probably with some question. Why should WIPO be interested in UDRP, Unified Domain Name Dispute Resolution Policy? I wanted to highlight that domain names are not just simple website or just web addresses. Domain names are important part of the brand identity and reputation. And it takes a lot of time, energy, and investment in order to create some customer trust. So when your brand is infringed or misused to deceive consumer online, WIPO in this case is a global leader in domain name dispute resolution who can help you to reclaim the infringing domain name and by using enforcement tools such as UDRP or national CCTLD option. And this is country code top level domain option of UDRP. So the primary framework for resolving domain name dispute at WIPO is UDRP, and it was created in 1999. And so UDRP applies for dispute over domain name registered in generic top-level domain names such as .com, .net, .org, and much more others. And in addition to this, Center also provides domain name dispute resolution service to more than 80 country code top-level domain registries. So we can see, so for the last 20 years, it was registered and managed by WIPO over 68,000 cases, while last year, 2023, was the year with the largest number of the cases since we received 6,192 cases. And so why the party should prefer to file in complaint with the WIPO Center, and what kind of benefit to proceed with a domain name dispute resolution at WIPO? First of all, this is time and cost effectiveness. The administrative process of domain name dispute resolution is pretty faster than traditional litigation. Usually it takes 60 days in order for panel to render the decision, and it is generally less expensive than traditional court hearing. Secondly, there is pretty straightforward remedies. As the outcome of the decision, it can be either transfer or cancellation the domain name, and the implementation of this domain name decision happen on the registrar level. Thirdly, there is international scope of resolution, which is enforceable across many other jurisdictions around the world. Of course, we should not forget about expertise, because WIPO panelists are truly expert not only in intellectual property sphere, but also in domain name practice. And of course, some kind of advantage for to providing this dispute resolution service, there is WIPO diverse linguistic potential, because the team of the WIPO Arbitration and Mediation Center is pretty diverse. It consists over 25 nationalities, and basically it can help us to provide service in more than 20 languages. Here there is information which shows the life cycle of UDRP complaint from the filing complaint until the decision notification. So usually UDRP process involved from 7 to 10 simple steps. First steps is complaint filed electronically with the center, and on the request of the center, registrar provide the information about registrant of the domain name. Then, taking into account this information, we are coming back to the complainant and disclose the information about registrant of the domain name, and ask complainant to submit amended to complaint towards this disclosed information. Afterwards, center provide compliance review, and as a result of this compliance review, we are proceeding with a notification of complaint. This is basically stage where dispute resolution cases has been started, and in these particular documents, there is rights and obligation of the parties, how they can participate in the proceeding. And usually respondent in this case, who is registrant of the domain name, it granted 20 days in order to participate in the proceeding and to submit any response to the complainant submission. Afterwards, there is panel appointment, and usually panel has 14 days in order to render the decision. And afterwards, we are proceeding with notification of decision. So the process is pretty straightforward, and it takes up to 60 days in order to proceed with the final outcome of the domain name case. And of course, there is sometimes parties prefer to settle the case, which can be an option. And in this case, center allow for a proceeding to be suspended, and it can be suspended for 30 days. And sometimes in some circumstances, it can be suspended even until 60 days. Here, let's talk about number. So there is a graph which showing the WIPO domain name case law trend for the past decade. So on average, center receiving at least 22 new cases per working day. And we can see through this graph that since 2019, since COVID time, caseload has been increased for 56%. And last year, as I have mentioned, it was the year of number of record year of number of receiving cases, and it was more than 6,000 cases. Here there is information how you can file domain name case online using WIPO e-filing system. And for this, it's necessary to fulfill WIPO model complaint for UDRP. For more information, you can follow the QR code and you will see information directly from the website. And in this particular complaint, complainant must demonstrate that domain name is identical or confusionally similar to a trademark or service mark in which complainant has the rights. Also, complainant should highlight that the registrant has no rights or legitimate interest in respect of the domain name. And of course, the domain name has been registered in and being used in a bad faith. And all these three factors should be considered in the complaint while a center is accepting this. So for correct filing of the domain name case, you need simply to upload this complaint together with other requested information about the parties, register, and also domain name itself. And yeah, of course, next slide shows information how you can file a response using this WIPO e-filing system. And for this, it's also necessary to fulfill the information about the respondent and domain name, and also to upload the response. And the model of the response also is shared of the WIPO website. You can follow this QR code and find more information about this. And as I mentioned earlier, WIPO provide its service through enforcement tools. And one of the enforcement tools is UDRP, what I have been mentioned. And another enforcement tools, this is basically variation of UDRP, which is country code top level policy. And considering this in 2000 year, WIPO issued CCTLD program, and it was done on the request of some member states who asked center to provide some assistance with the CCTLD. And starting from 2000, so center has already a service provider for more than 80 CCTLD registries. And in addition to administration of the IP-related dispute, center also provide advice on new dispute resolution policy, and not only because it also can help to tailor and update the existing dispute resolution policy. And so on June 2024, like recently, we have new WIPO guide on CCTLD program, what has been published. And to get more information, you can follow this QR code, and there is a flyer and also CCTLD program, and you can be updated with the recent changes. Here there is a map which shows that what kind of CCTLD with whom we are cooperating. So we can see that some CCTLD registry adopt UDRP directly, while other registry prefer adopt this UDRP-based procedure, considering some national consideration. And here, which is a map which shows that, so in green color, there is registry who adopt UDRP directly, while in white color, there is proposed for your attention some variation of UDRP. As we can see through the map, there is also .ua service, a .ua registry. And so in Ukraine, there is variation of UDRP. There is .ua dispute resolution policy, which consider also some national particularities. So next slide show some top 10 WIPO CCTLD for the last year in numbers, and we can see that the leading domain zone were .co for Colombia, .cn for China, and .mx for Mexico. WIPO also provides service for .ua, as I mentioned, and there is some specific page for on WIPO website how WIPO provide dispute resolution service for .ua. The legal basis for this there is .ua domain name dispute resolution policy, what has been approved by Ukrainian registry postmaster, and it was on March 2019. And of course, this .ua policy is different from UDRP, and sometimes it's even including some substantial criteria and proof on which is resting on complainant who wants the domain name to be transferred to him or to her. And we can see that this policy is applicable to some specific domain name, second level domain name, and this is .ua, to third level domain name .com.ua, and also some number of third level domain name up to 30, which consists the name of the city or Ukrainian city or variation of Ukrainian city. So there is only basically 33 domain names, what is applicable under this .ua policy. So yeah, as I mentioned, there is some legal framework for resolving .ua dispute. And yes, of course, one of the main document there is .ua policy. But in addition to this, there is also rules for .ua policy and also WIPO supplemental rules for .ua policy. But I also wanted to pay attention on some new decision, what has been adopted on July 2023, last year. So it was decision on the peculiarities of the application of .ua policy and .ua rules under the legal regime of martial law. And this document is very important because it provides some kind of safeguards, procedural safeguards in .ua proceedings. So this particular document provides some kind of extension for parties. For example, for .ua register, the due date for submitting their registrar and verification, but it's not related to log the domain name. So this deadline can be extended on the request up to 14 calendars day. And this is in addition to 2 business days, as it was mentioned in .ua policy. Also, there is some safeguards for a respondent. So for respondent, the due date for submitting their response, it also on the request may be extended up to 14 calendar days, in addition to 20 calendar days. So as a result, respondent have a chance for 34 calendar days in order to participate in the proceedings. And also there is another safeguards for respondent in order to submit the court action to the national court in order to stop the implementation of the decision. So it also on request may be extended up to 14 calendar days. So in addition to 10 business days, as it was set up in .ua policy. So this kind of safeguards provide opportunity for party to participate into the proceeding on equal basis. And yeah, here there is some example of .ua cases, and I would like to pay the attention that all cases we are publishing on WIPO website, so you can have a chance to look through all this decision by yourself. And yeah, it's my pleasure to give you some brief overview about domain name dispute resolution at WIPO, covering some CCTLD program together with .ua proceedings. And if you have any question, you can, there is some email, and we would be glad to cover all your concerns. And also, if you have question now, it's my pleasure to share my experience with you. Thank you so much.
Пані Лідія, щиро дякую.
Lydia, honestly, want to thank you very much for these statistical data. It means that there is great demand for mediation in domain name dispute resolution. And special thanks to you for presenting in this detail how the procedure works itself, because the surveys that we were doing at the very beginning of this event means that 73% of our participants have never had any experience in mediating those cases. I think this presentation was really instrumental and helpful for our audience. I want to remind our audience, please, whenever you have any questions, type them in the chat and we're going to consider them at the end of the panel discussion. All right, it is my pleasure now to give the floor to Marisol. Earlier on, she worked as an attorney at so many different settings, and she specializes in IPR. Recently, Marisol joined the Appeals Chamber from the EU IPO, where she is a project manager and she manages the establishment of the new project. She was accredited as a mediator. Marisol, please, the floor is yours.
Thank you very much. Allow me to share my screen. Okay. I hope you can now see it properly. So good morning, everybody. Thank you for the kind introduction, Oleksandra. It is a pleasure to be here today in this session for mediation in IP disputes. Before I start, I would like to briefly thank the organization of the event for the assistance and effort and for being so helpful in the arrangement of the session. My name is Marisol and I am working at the Boards of Appeal ADR service at the European Union Intellectual Property Office. And today I would like to talk about the EU IPO Mediation Center and more specifically, how users can make the most of mediation and ADR when dealing with disputes involving IP rights. After a brief overview of what the EU IPO Mediation Center is about, I will present why is it interesting and practical to consider. We'll see what services we offer at the Mediation Center and how it works. I'll continue with a few hints on how you can find out whether your IP dispute is suitable for mediation. And I'll end up my presentation by giving a brief overview of what have been the first 6 months of the EU IPO Mediation Center. The establishment of the Mediation Center took place on the 22nd of November of last year. The main objective of the mediation center is the one that appears on the slide, to provide complementary, voluntary, confidential, and accessible dispute resolution options to users so that they can choose the most appropriate path in the event of an IP dispute. And regarding our legal basis, the establishment of the Mediation Center is foreseen in Article 170 of the European Union Trademark Regulation. And the other essential reference for us is the decision of the establishment and operation of the Mediation Center, which entered into force also in November last year, and the decision on the rules on mediation. I would like to underline the huge potential of alternative dispute resolution for inter partes proceedings at the WIPO. Every year, the office receives approximately 200,000 trademark applications and 100,000 designs. So it gets around 300,000 new IP files every year. This amount of applications obviously triggers a high volume of disputes, around 24,500 inter partes disputes every year. So
If you
while
can
the main
be a little bit slower, that would contribute to the interpretation quality. Thank you.
Okay, sorry. So while the main dispute resolution path of the office is to produce decisions, many of these disputes can be potentially mediated, so parties can find a friendly solution adapted to their business interests. And ADR is highly effective. This is shown in the high percentage of successful mediations. So 70% are settled with agreement of the parties, and the high level of satisfaction of our users with the process, which is around 80%. So why an EU IPO mediation? The EU IPO Mediation Center services are available to the parties involved in inter partes proceedings before the office. Let me underline 4 features of our services which are particularly interesting for dispute resolution. So first, mediation is at no additional cost for the parties if conducted online or at the EU IPO headquarters in Alicante, in Spain. No additional fees need to be paid to the EU IPO apart from the fees that correspond to the relevant inter partes proceedings. For instance, the opposition fee or the appeal fee. Second, our mediators are EU IPO staff members who are experts in intellectual property and who have undergone specialized mediation training with internationally recognized ADR training institutions. Our mediators are also multilingual. So we offer mediation in the 5 working languages of the EU IPO and other official languages of the European Union. And to efficiently manage and support the dispute resolution process, we have introduced a modern online ADR platform that allows the parties and the mediator to interact virtually in a secure environment, either prior or during the mediation sessions. We offer different types of ADR services to adapt to the needs of the disputes and the parties. So mediation is indeed our flagship service, which enables the parties to reach an amicable settlement with the assistance of a mediator. Then we have conciliation. In conciliation, the conciliator assists the parties in reaching a settlement by suggesting possible solutions on the substance of the disputes. As in mediation, in this case, the conciliator is neutral and impartial and has no authority to settle the case. The settlement must be agreed by the parties. And the specific about conciliation is that it is always the rapporteur of the case pending before the EU IPO. Then we have expert determination, which takes place in the context of a mediation and consists of a process which allows the parties to appoint an expert to provide an opinion on a legal, commercial, or technical matter that prevents them from making progress in their negotiations. Then we have friendly settlement, which is an invitation by the case handler of an inter partes proceedings in the first instance for the parties to consider talking to each other to reach a friendly settlement of their dispute. And in this case, the case handler does not mediate or intervene in the discussions. And finally, the Mediation Center's case management team manages the ADR requests and the procedural aspects of the ADR processes. They also guide the parties in the suitability of ADR mechanisms and facilitates contacts between the parties. So what disputes can be mediated? To request ADR WIPO, there has to be an inter partes proceedings pending before the office. Therefore, the dispute must be linked to an EU trademark or a registered community design. This can be considered the entry point to trigger a mediation at the WIPO. However, it is often the case that parties can, and indeed they do, include other IP rights in the mediation, such as copyrights, domain names, or patents, as well as any other related disputes pending between the same parties in national IP offices or national courts anywhere in the world. So the steps of the mediation process at the WIPO are summarized in this slide. The first step is the initiation. So mediation can be started in 3 ways: through a unilateral request, when one of the parties involved requests mediation. The mediation center case management team then will contact the other party in order to inform them of the request and confirm whether they agree to initiate the mediation. Another possibility is the joint request, when the request comes from both parties to the dispute, and in this case, the mediation center will proceed to organize the process. And finally, we have the proposal coming from the rapporteur of the case or the case examiner at the relevant instance pending before the WIPO. And these people may suggest that the parties consider mediation in the particular dispute. If both parties agree to proceed with mediation, the WIPO will suspend the proceedings until the end of the mediation, and then the mediation center invites the parties to appoint a mediator by suggesting possible candidates, and my colleagues in the mediation center will also send the mediation agreement that must be signed by the parties and the mediator. Step 4 would be the mediation phase, which consists of the actual mediation session or sessions. And finally, the conclusion of the process, which will be confirmed formally by the mediator, who will inform the mediation center about the outcome, and the center in turn informs the relevant instance to lift the suspension. The main proceedings will then be resumed, and the parties may need to follow up to ensure that the terms of the settlement are implemented before the WIPO. Let's see now how to request mediation in practice. So there are 2 options. The first one would be to go to the mediation center website and write to our functional mailbox that appears on screen. And the second option is that mediation can be triggered throughout the WIPO user area by sending a communication requesting mediation in relation to the inter partes proceedings. As a guidance, the office has identified 10 reasons why an IP-related dispute can be particularly suitable for mediation, which you can also find on our website. So in the first place, mediation can be particularly effective if it is considered at the earliest possible stage of a dispute. However, mediation may still prove to be the best solution when the dispute is at an advanced stage, as the parties may prefer to avoid investing further resources in court. Then the more complex the dispute, the bigger benefit of mediating the case. This is particularly relevant when, for instance, multiple jurisdictions are involved, there are multiple pending conflicts between the same parties, or the dispute involves several IP rights. The third reason would be when a court decision in the dispute would be difficult to enforce. This is relevant in cases where there are insufficient assets to enforce a future court judgment, or when the enforcement may take place in an unfamiliar jurisdiction. When the parties have or may have coexisting IP rights, this is a good indicator of suitability of mediation. And this could be because the parties are interested in different business areas or even territories. Mediation is appropriate when the emotional and personal aspect of a dispute requires a tailored and flexible approach. For example, in cases involving family-owned businesses or former business partners. When the parties are interested in preserving an existing business relationship or perhaps establishing a new one, mediation is also an excellent mechanism. And again, when confidentiality is important for the parties, then the strict confidentiality of the mediation process is especially useful. And this is also the case when the parties wish to preserve their business reputation by avoiding public conflicts or tensions with partners or competitors. Then number 9 would be when a language barrier exists between the parties. And again, the flexibility of mediation is very useful since the parties can agree on a common language to be used. And finally, if the parties have an interest to resolve the dispute quickly, mediation can be as fast as the parties wish it to be. Now, allow me to give a short overview of the latest updates of the Mediation Center since it was launched in November last year, and what are the priorities for the next months. So the challenges and priorities for 2024 essentially focus on expanding mediation to our first instance proceedings. We have started with cancellations in July, and we are now preparing the next rolling out, supported by also an adaptation of our online tools. Meanwhile, we will adjust the internal mediation capacity and train mediators to support the future demand. In terms of stakeholder engagement and cooperation, we work closely with judges from European Union trademark and registered community design courts in mediation. We cooperate with them in mediation matters, and we have our mediation center stakeholder network composed by representatives from user associations, European Commission, and other mediation centers, among others. And in terms of user awareness, I will give you more information in the next slides. And I would like to also mention that in parallel, we are also supporting new competencies coming our way, and as it is already the case for mediation in the new regulation on craft geographical indications. So we have been working on increasing direct contact with IP representatives in order to propose cases for mediation. For this, the boards of appeal and first instance have established an early case management pilot, and we have already very good feedback with higher number of ADR proposals and more cases accepted for mediation. So there has been an increase in 82% of mediation proposals, and around 30% of these proposals end up being accepted by the parties. In parallel, we are also preparing the training for new internal mediators, so we should have around 20 new mediators by the end of the year. In terms of user awareness raising and promotion, until now, we have put ADR on the agenda of 19 events and meetings with IP practitioners, and we have reached more than 2,500 IP practitioners in these events. We have launched a joint awareness campaign on ADR for SMEs with national and regional IP offices. For the time being, 17 participant IPOs have participated, and there have been in this campaign more than 28,000 impressions and around 1,000 engagements. And to finalize my presentation, I would give a brief point on where to find more information. First, our webpage at the WIPO website, you can use the QR code. And also, if you will have access to the presentation, you can click the link to go directly. There you will find plenty of information, among which I would recommend 2 basic brochures that you can download in PDF. One about the Mediation Center and the other focused on the benefits of mediation oriented to SMEs, which was developed in collaboration with IP offices as part of the European Cooperation Project to support SMEs. And of course, the Mediation Center email, where you can ask any question, guidance, or send a request of ADR for any dispute pending before the office. And with this, I finish with my presentation. Thank you very much for your attention.
Дякую, дякую, пані Марісоль. Коли я почула, що
Thank you,
ви
Marisol, very much. When I heard that you position this service as a flagship service, I already gave you a heart in my comment. Indeed, this is impressive. Your accomplishments are impressive. Even though you are quite young, since November last year you've been working, but you've been developing very quickly and progressively, and you've been very active. This shows that you've been working very well indeed. We have some questions in the chat, but I remind everyone that we will answer all the questions at the end. Jeremy Lack is already responding to some of the questions, and I'd like to give the floor now to Oleksandra Lokon. She's a lawyer specializing in intellectual property issues, particularly trademarks and industrial samples, and she is IPO. She's a lawyer, and based on her multicultural approach, she's fluent in Spanish, English, German, Italian, and French. And your center basically conducts business in 5 languages, and that's very good.
2014 року пані Олександра працювала юристом з питань
Alexandra worked as a lawyer in large companies in Madrid, Vatican, and became recently an accredited mediator in London. And since then, she's been working with EU IPO. Thank you. The floor is yours, Alexandra.
Thank you very much. Thank you very much for your warm welcome. Dobry ranok. I hope I got that right. And thank you for inviting me to this conference, of which I would really like to praise its excellent organization. So let me share my screen. I hope I get that right. Okay. Okay, please let me know if it is not okay. Otherwise, I will just go ahead. So I've been asked to provide some practical aspects from my mediation experience at the EU IPO. I will split the presentation into 2 parts. In the first, I would like to give some tips regarding the preparation of a mediation. And in the second, I would like to give you some of the advantages of mediating in IP disputes based on some practical examples from mediations at the EU IPO. By the way, I'd like to clarify, so the Center of Mediation at EU IPO was indeed founded in November last year, but we have been conducting mediations at EU IPO since 2014. I think the first mediation started. So we have been practicing for a time, and I have been very lucky to be able to form part of the mediation group since its very beginning. Okay, so as mentioned by Marisol in her presentation, these are the phases of a mediation before the EU IPO. First, there is a request or proposal for mediation, and what follows is the preparation phase before we enter the actual mediation day. From my point of view, the preparation phase is essential for a successful development of the actual mediation process. So I will focus on that. As you know, in most mediations, there are 3 main actors: the mediators, lawyers, and the parties themselves. All of them can, of course, prepare well in order to guarantee a successful outcome of the mediation. The mediators at EU IPO are also IP experts, specializing on trademarks and designs. Since the mediations begin with a conflict before the office, which may be either an appeal or a cancellation action, the mediators are able to consult the file beforehand, so we can understand the legal issues of the conflict. However, mediators at EU-IPO do their best to help the parties and their lawyers to prepare for the mediation. Here are 4 different issues that I like reminding the parties of and their lawyers when preparing for a mediation in a conflict involving IP rights. Firstly, it is important to make sure that the parties have full authority to take decisions. Before the mediation, it needs to be clear that someone who takes the decision for the company is present, and not only their lawyers. Ideally, a CEO with full capacity to take decisions should be present during the entire mediation day. Secondly, we urge the parties to understand the mediation process and encourage them to ask questions. We usually give them an outline of the process via email and offer them to contact us by email or phone if they have any doubts before the actual mediation day. Thirdly, we ask the parties to provide the mediator with a written summary of the background to the dispute. Specifically, we ask the parties to concentrate on commercial aspects of the conflict rather than on the legal issues. And finally, we ask the parties to think about important issues to be addressed, maybe even to start preparing their first offers while they clarify their expectations and reconsider their positions. And how do we do this? We do this with a questionnaire. We have observed that receiving answers to specific questions regarding the conflict before the actual mediation day is very helpful, both for the parties to better understand their strengths and weaknesses of their case, and for the mediators to get a better insight, also to the commercial aspects of the conflict. Of course, these questions may be modified, depending on the nature of the dispute, and they're not carved in stone. Here are some of the questions we use. I understand you have access to the presentation, so you don't need to copy them now. This way of proceeding works very well for us, since 90% of our mediations are online following the pandemic. We have verified that a good preparation of all actors involved helps enormously to facilitate the path to understanding and finding an agreement on the actual mediation day. It is essential that the parties do a risk assessment and a reality check before they start the mediation, and asking the right questions before the mediation day gets them thinking. However, even in spite of the preparation, issues may rise during the mediation process, which may be the same in a mediation concerning IP issues as in a mediation in any other field. Here I would like to show you a real example of a case that happened before the EU IPO. It regarded a conflict between a large US company, Company A, and a small company based in the EU, concretely in Germany, Company B. Both of them were in the sports clothing sector. Company A had filed a EU trademark at the EU IPO, and Company B opposed on the basis of an earlier company name. In spite of preparing the companies before, during the actual mediation day, Company A appeared with 3 lawyers and 2 in-house lawyers, but the CEO was reluctant to participate. He said he had no time. For Company B, only 1 lawyer and the CEO appeared. So already in the opening phase, the mediator was confronted with a problem of imbalance of representation and the lack of authority from one of the parties. It was a classic David versus Goliath situation, where the small company found itself in front of this huge company who from the outset had more power. It is the mediator's task to keep both parties on an equal level, no matter who they are, how large they are, and how they are represented. It must be made quite clear that in mediation, both parties have the same weight, the same right to speak and to be heard. And the parties should receive the same amount of attention from the mediator, who must guarantee that things are kept fair without losing impartiality. Obviously, in this case, the CEO of Company B was frustrated when the CEO of Company A did not appear. He perceived the absence of the CEO from Company A as a lack of respect and as a proof of the imbalance and unfair situation from his perspective. So you can imagine that the beginning of the mediation day was quite tense. However, moreover, there was a lack of authority. Even in spite of the lawyers representing Company A, none of them had the competence to take decisions. In this case, I can reveal that the mediator managed to get an apology from the Company A CEO, which was very important to calm down the other side, as well as his assurance that he would join in later on during the mediation day. In the meantime, the in-house lawyers would obtain an immediate consent from the CEO for all that was decided. This was accepted by Company B and the mediation could proceed. Let's pass on to the second part of my presentation, where I would like to briefly explain the advantages of mediating a dispute concerning trademarks and designs, which is what we most deal with at EU IPO. And I will begin with some practical examples. In this first case, I would like to give you an example of how a settled solution helped involving the parties' IP rights and saving costs and precious time. It concerned a dispute between two EU-based companies that had similar product labels. Both companies produced cosmetics and had registered their trademarks at the EU IPO and at national level. Both of them had a trademark which included the same word and were overall similar. Legally, both companies were at loss as their signs were weak and because they coincided in a descriptive element, which is frequently the case in the cosmetic field. What could have happened if the parties had continued litigating? Both might have lost part of their trademark rights after many years of disputes before the EU and national administrations and courts, as well as many tens or even hundreds and thousands of euro. What could be achieved with mediation? The parties could agree to redesign their respective trademarks. The party holding the earlier rights received a compensation instead of losing all that money in litigation. And most importantly, both parties could maintain their trademark rights once all EU and national proceedings were closed. By the way, I would like to mention here when we speak of national proceedings, as long as there is a conflict in the EU IPO, any other national proceedings may be included in a mediation before the EU IPO, so also before the Ukrainian national office and before any other national office in or outside the EU. So let's pass on to a second example, where I would like to talk about a dispute between a beer producer who had filed a EU trademark with the intention of filing an international registration designating 20 countries in the whole world. This beer producer had a very large global project, which was jeopardized by the owner of a restaurant in Paris, who held a reputed trademark in France for alcoholic beverages, which was highly similar to that of the beer producer. What would have happened if the parties had continued litigating? Well, probably they would have lost a lot of time and money in the proceedings before the EU IPO and the courts, and the beer producer may have lost his trademarks and would have not been able to make business. What a missed commercial opportunity. However, what could be reached with mediation? Well, the parties could sign a coexistence agreement, maintain their marks, and agree to cooperate on a business level. So what does a happy end look like in a mediation before the EU IPO? In mediations concerning concretely trademarks, the agreed solution may include different aspects, such as the limitation of the scope of protection of the confronted marks, the signing of coexistence agreements containing non-attack clauses, the agreement on a specific use of the trademark, or only in a specific territory. The solution may also include the transfer of trademark rights from one party to another, or a license agreement between parties. Obviously, the same goes for registered community designs. At the same time, concerning the proceedings before the EU IPO, these are usually concluded with the withdrawal of the trademark application or of the opposition, or of the cancellation request or of the appeal, depending on the proceedings and at which stage they were, or with the recordal of a transfer of rights. Also, the settlement of a mediation before the EU IPO may include the settlement of other conflicts before other national administrations and courts, as mentioned before, which were included by the parties in the mediation. However, these withdrawals or whichever steps have to be undertaken have to be enacted by the parties and their lawyers directly there. Obviously, EU IPO cannot influence that anymore. So to conclude and summarize, the advantages of finding an alternative resolution to a dispute before the EU IPO are multiple, as a conflict can involve different IP rights and proceedings before different offices and jurisdictions. The main objectives of the mediations at the EU IPO we share with all other institutions such as WIPO and companies offering mediation and private mediations offering this form of assistance for a friendly settlement. And these are mainly to empower the parties, giving them the opportunity to manage their own solutions rather than depending on the uncertainty of an administrative or court decision, to find what are often global, wide-reaching solutions agreeable to all of those involved, and of course, to save costs and time so that these may be invested in actually getting the business running. So this is all from me. Thank you, Дякую. And I'm looking forward to your questions.
Пані Олександра, я вам дякую.
Alexandra, thank you so much for your fabulous presentation. Please type your questions to Alexandra in the chat. And once we have time at the end of these presentations, we can allocate it specifically for Q&A. Our speakers can equally read the questions in the chat. If they specifically can see questions to themselves, they can keep answering them. And now it is my pleasure to give the floor to Aurika Grybowska. She's in charge of the Ukraine's IP Office Mediation Center. So, Aurika, the floor is yours.
Доброго дня. Зараз хвилину.
There's so much feedback. Sorry.
Так, все добре. Дуже дякую за
Good morning. I
запрошення.
want to thank you very much for the invitation to take part and be a speaker at today's forum. We have such a respectful audience as well as speakers. Very talented moderator, by the way. I personally know her. She will be a punitive body for me. She'll be stopping me if I spend too much time for my intervention. I'm so glad to see everybody. Thank you very much for the support from the Ukraine's Mediation Academy. They help a lot to the Ukraine's IP office. They help us to disseminate mediation in Ukraine based on IPO here. For us, this is really valuable. So special thanks goes to Luisa, and thanks a lot for all the materials and information that you deliver to the IPO in Ukraine. Right now, Luisa and I we're preparing a video on mediation in Ukraine. So once again, thank you so much. Let me start with my presentation. Hang on a second.
Чи все ок, чи видно? Так, видно?
Is everything on the screen? Can you see it? Yeah, let me tell you about IP mediation based on IPO here in Ukraine. We are governed by the mediation law in Ukraine and the statute of the Ukraine's National Intellectual Property Office, as well as we're implementing the MOU that Isha mentioned at the very beginning. We signed it between the Ministry of Economy of Ukraine and the WIPO. Our IP office tries to foster and promote mediation in Ukraine as one of the tools. For that reason, we established a specifically dedicated office. Among the key objectives of the center, it is raising awareness about IP mediation in Ukraine, supporting the IP mediation development, contributing to organizing mediation processes in IP dispute resolution, as well as enhancing qualification and specialization of mediators in intellectual property rights, and of course, international cooperation. The IP office, since the very beginning of its path, when we just started our IP center in Ukraine, we approved all the statutory papers that we are governed by. They were adopted in September last year. This is our statute on the mediators registry that are involved in IP dispute resolution. And this engagement, of course, requires the register of mediators in Ukraine. Then we have the mediation, IP mediation, dispute procedures, clearly designed and detailed. And of course, we have the professional ethics code. When those documents were adopted, it is important to mention, for us, the role model was the WIPO. We took into consideration their experience. This is our role model indeed, and we adopt our documents based on the WIPOs, those of WIPO. And of course, the Code of Professional Ethics is almost identical to that practiced in the European Union. What the center does, we actually create a platform for dispute resolution in intellectual property cases. At the same time, the IP office remains to be neutral. We don't take sides. We're not involved directly in the mediation procedure. We do not pursue any interests of any of the parties. We're absolutely neutral. We only help organize the procedure. And for this, we maintain our registry, and we can actually provide consultancy and advice to the parties. We can also assist in organizing the procedure, provide for safeguards and remedies to ensure confidentiality principle, which is one of the core solutions for mediation. This is exactly what the office has been doing, at the same time remaining neutral in the mediation procedure. How does the procedure work? First of all, there is a complaint filed by a party or several parties. There can be several of them. In case this is an initiative of a single party, then we assist them in organizing everything and invite the other party to the mediation procedure. Then, of course, we have an advisory meeting. This is like an orientation meeting where we explain the procedure and the principles, possible impact, how mediators work and what do they do, what can be additionally done within the mediation session, and other issues. Then the parties can actually select mediators from the register. This is fully their discretion, and the IP office will not interfere into this process. Only whenever there's need for advice or any kind of consultancy support, when they need more expertise or special background for the mediator, we can advise them to select a specific mediator or recommend someone, but this is not a mandatory procedure whatsoever. Of course, there is an orientation meeting with a mediator, or mediators, if there are several of them involved. And then there is a process of mediation kicked off. And then after this, the parties can reconcile or consider any other options. The options are also possible, but we have quite a high success rate. Here, there's more information about how to initiate the procedure. It is also available in English, provided for the organizers. This is how the procedure actually looks like, how to fill out an application for mediation. It is also an established form or format, so that it is easier for a party to apply. So we were trying to implement the various online tools for more agility. This is how our register looks like. Please go ahead, scan the QR code, and you can actually see how it actually works. Anyone can actually go to this register. And regarding registration, anyone who is proficient in mediation and recognized as the genuine professional can be registered over there. I'm not going to be telling you a lot about the orientations meeting. Let me tell you something. Again, like our colleagues have mentioned, the online procedure and the online mediation is more relevant today, specifically for the Ukrainian context, given there is war and some of the territories are occupied. So many people are abroad, they're displaced. That's why one part of our strategy for the present day moment is to implement more efficient online tools. And we also want to contribute to all the other solutions like the WIPO is doing to foster online dispute resolution functions and opportunities. When mediation is taking place offline, in person, then the parties can agree where the session can be hosted. They can do it at our premises. However, if the parties want to select another place, another venue, an office, or a different location, we're also supporting that. We have full flexibility, and this is our key principle. Now, with regards to another step, which is so important, this is awareness building or awareness raising. This is what our partners have alluded to a lot. And thanks very much to the World Intellectual Property Office. We have been closely cooperating with them. We do trainings together. We also have specialized IP mediation trainings. We have the discussion club as well that was started together with the support from our partners. We engage mediators and also trustees, lawyers, and attorneys at law to those trainings. We publish a number of different materials like guidelines, studies, as well as handbooks for practitioners, depending on requests from our clientele. We work with the top Ukrainian universities and civil society organizations and try to disseminate as much as possible these mediation procedures. By scanning the QR code, you can actually go to see our projects. They're available publicly, so you can just go there and read all the information. We have the IP mediation guideline. And this is our team from our office. You can see them here in the room, in the virtual room. But whenever you want, we're ready to cooperate with you. We are ready to support you on this path to disseminate best mediation practices and ready to cooperate in any possible setting. Whenever you have any proposals or opportunities to offer, please welcome anytime. Thank you.
Пані Оріка, дякую за вашу
Ulrika,
презентацію.
thank you so much for this presentation.
Ми досить обмежені в часі.
We're quite limited in terms of time. And without any further ado, let me hand over the floor to our next speaker, Jeremy Lack. Jeremy is a Swiss, US, and UK lawyer specializing in international IP disputes and appropriate, or I'll say alternative dispute resolution. He's had more than 500 mediation sessions and arbitration sessions on IP complaints and cases. He's a certified IMI mediator and a practicing arbiter. He is part of the Who's Who leader, and he's an opinion leader indeed. He graduated from Oxford and works in English, French, and Spanish, lives in Switzerland, and has designed a lot of tailor-made solutions for commercial IP disputes. Jeremy, the floor is yours, and we want to thank you so much for taking this active part in our today's forum, and you'll keep answering those questions, for which we want to thank you so much indeed.
Well, thank you very much to all of you. It's a real honor and a privilege to be able to address you all. And my hearts and thoughts go out to the people of Ukraine these days. It's not an easy time. And to all the young soldiers, unfortunately, on both sides. In any event, let's talk about something that hopefully will be more positive and help to change to a better world, which is the idea of mediation and a mediative approach to resolving conflict as opposed to a positional one. So I want to try and look at mediation in a more holistic way. My colleagues from WIPO and EU-IPO have done a fantastic job of summarizing what mediation can be about. But I think in IP, there are some specific problems that we need to address and recognize when we look at process design. And what I'm going to do is try and take them into consideration, especially trying to look at the difference between mediation and conciliation. When do you want a neutral who will be there to help you shape a business solution based on needs and interests which are subjective, as opposed to an expert in the law, in the IP, or whatever the field is, who's going to make proposals and tell people where they think a settlement should be found, which is more evaluative, even if it's not an imposed outcome. And I think that's a key difference in understanding an IP dispute and how you wish to approach it. But let me start off also with the results of today's survey. So at the beginning, we saw the results of this survey, where although 93% have never had an IP dispute, there seemed to be this kind of common thinking that you need to have some sort of expertise by a mediator. And that is really important to maybe not only have expertise imposed in the qualification of mediators, and also that it is very important to have some kind of mandatory selection or phasing process. And I would really encourage you not to go down that route of thinking, especially as after you've done your first mediations. The question is it important to have IP expertise or industry-specific understanding or expertise? Mediation for me is about understanding the needs and interests, the business needs and interests of the disputants. It has nothing to do with understanding the technical merits of a patent or trademark. And so I think as we go forward, please bear that in mind as we think about what is the most appropriate way of doing this. The problem with the IP world is that we are stuck with the picture on the left. We still think of IP nationally and territorially. And although we do have harmonization at various levels, harmonization is not working very well at the practical level for all of us. The UPC is a nice new feature moving in the right direction. We do have harmonization in the form of the European Patent Convention. WIPO's PCT is really making a huge difference worldwide, as its other conventions on designs and copyrights, the Berne Convention. Let's not go into that. The fact is that when you need to enforce an IP right, you're still stuck with a country-by-country mosaic logic of what happens. Whereas what business people need is the picture on the right, and that's what mediation can bring. A way of resolving conflicts without having to be limited by nationalistic approaches and thought and thinking. But IP is rife with problems in a practical way still today, despite these harmonizations. First of all, we tend to confuse different IP rights, trademarks, copyrights, designs, patents. Even in the chat today, one person was asking a question about copyrights for COVID drugs. And they really, I'm assuming, intended to ask about patents. So we have fragmented rights which overlap in the same IP, and it's all intangible. So it's very difficult to try and keep track. By the way, I apologize to the translators. I realize I'm going a bit too fast. I'll try and slow down. But time is pressing, and there's a lot to cover. However, so we have these fragmented rights. We have fragmented geographies where the application of the law still remains very different country by country. We also have fragmented professionals because there's a big difference between an agent and a lawyer. And even within the lawyer community in IP, you have those who do transactional work like solicitors or commercial lawyers, and you have barristers and litigators. And they do not think about IP in the same way either. So, and finally, there's a fragmented logic. People tend to think either or. Do we think either in terms of patents or trademarks or designs, and not and? What is the collective pattern that we need to look at here? Most IP conflicts tend to involve a broad range of IP assets. And when we start to break them down by country and by subcategory, it becomes impossible to manage, especially given the variabilities in country-to-country law. And this is where I find the greatest help for mediation is. It helps to cut through all of this and simplify and help reach business decisions. Let me just give you visually a few slides. I'm not going to spend much time commenting on them, but just to give you a sense, these are the key jurisdictions involved currently in enforcing IP rights. And what you will just see is that it's a chart with every single country having a different system and a different way of looking at these things. And so already you can see some of the geographic fragmentation I was mentioning to you. The fact is that if you look at the piece of cheese on the right, I'm from Switzerland, we like cheese in our presentations, there is this different understanding of the value of the piece of cheese if you just look at the dimension you are looking at in the three-dimensional object. If you're on top, you see a triangle. If you're on the right, you see a rectangle. And if you're on the other end, you see a square. And different courts in the IP world tend to look and think this way about the value of IP and what is going on. There was a very interesting discussion going back to 1999, where people were saying the problem with IP is that it is culturally influenced. Different countries have different visions and thoughts about IP. And so the result is that still today, despite the improvements, we are in a situation where I can confidently predict to a client who has an incredibly strong case that their best case is only 60% of winning. IP is notorious, and in at least 40% of cases, you can still lose despite having the strongest case ever, because there are so many variabilities in the IP field. That is another reason why I think IP is particularly appropriate for mediation. And just to explain to you how the IP world is dealing with it today, it's all through political compromises. This is a boring text. I don't want you to try and understand the text. It's a question about how do you interpret a claim and what is the importance of a claim in a patent. If you look at the GB, the red text, that's how the English law used to apply the situation. And although the UK is out of the EU these days, it still is influencing a lot the interpretation of IP rights. And then you had the German approach in green. And basically what happened was when some of the laws and the protocols on interpretation of patents were designed, they basically said, let's find a compromise between two different approaches. Those approaches were not abolished. They continue to exist. And so depending on who your judge is and depending on where they come from, you will get basically very subjective different views. So all of this is to say that you need a better system. We need a better system for resolving IP disputes. When we look at what the disputants want, that's the left column in this picture, what do they want? They want it to be fast. They want it to be, and I'm not going to say free, but they want it to be affordable. And affordable is certainly not what IP litigation is these days. Also, relationships need to be preserved. It is not very helpful in IP litigation when lawyers are being very positional and fighting one another, because that means the parties themselves tend to stop speaking to one another. There's also a need in IP to separate control of process, what evidence is shown, what confidential trade secrets may need to be provided, as opposed to the control of the outcome, who wins, who loses, on what. And those are very, very different views that need to be kind of taken into consideration in terms of what the users want. And finally, there's confidentiality, which people want, and which is very difficult to enforce at the very end if you have an award, even in arbitration. And you also have the problems of enforcing it in another jurisdiction. And so what disputants want, as you see in the middle, the arrows show, less time, less cost, better relationships, better control of process, better control of outcome, better confidentiality, and better enforceability. The systems are not offering that in any system in the world. And while WIPO and EU IPO are trying to provide some solutions to this, we still are in that world of a mosaic way of thinking, country by country, that we need to overcome. The problem that I also have, and is slightly invisible, is that even in these places, who you go to and their understanding of mediation can vary. And it's very important to look at IP disputes holistically. We need to look at each conflict as a full iceberg. We're not only looking at what is above the waterline, the facts, the law, the positions that the lawyers like to argue about, but especially what is under the water. And that has such things as needs, emotions, beliefs, because until we are able to take them into consideration in mediation, we will never be able to have a holistic solution that will really be able to address the problem. And when you only cut the top off the problem by dealing with facts and positions, an iceberg floats on its side and a new dispute will emerge above the waterline. And that is the problem of trying to deal with disputes topic by topic or country by country. We need to look at them holistically. Now, IP, I've just given you here a list, and you'll find it in the slides. I don't want to go over them, but there's all sorts of complicated cases that you can get in an IP dispute. We heard about standard essential patents and what is a fair, reasonable, and non-discriminatory license when you've got 4,000 licenses and you've got to apply what is the right royalty for all of them. It's very difficult to think about these things legally. You've got to be pragmatic and you've got to be looking at business needs and interests, not the laws. So let's now take a step back about why I care so much about the difference between who the neutral is and what the skill sets kind of required to appoint them are. So let's look at what is appropriate dispute resolution. Appropriate dispute resolution means you have a choice. You have a choice from negotiation to litigation, but with something in between. Most people tend to think that if your negotiation failed, your only alternative is to basically go to litigation. And that is not correct at all. As you can see in this chart, mediation, as distinct from conciliation, as distinct from arbitration, can offer you steps in between. And I'd like to look at that holistically if we want to have the mindset of shifting a business risk into a business opportunity. The wonderful thing in mediation is that you tend to get senior executives in the room. They are not interested in the legal technicalities of the prior art or what is covered by a claim or the technical rules of whether or not something is distinctive or not from a trademark perspective. What they care about is their business. They care about increasing their revenues, decreasing their costs, maintaining good relationships, market share, a stable workforce, good reputations, branding. That's what they care about. And none of these things will get resolved by spending a lot of time and effort on trying to understand legal technicalities. So do you want to keep in control, which is the northern part of this spectrum, or do you want to be giving up control and giving full control to a judge, a conciliator, as in the lower part? And I separate conciliation from mediation. Let me explain to you why. So first of all, before I jump into mediation, conciliation, or arbitration, important to also understand negotiation, because at the end of the day, these are all ways of facilitating a negotiation, because the parties in the disputants need to reach an outcome. And so we need to understand what sort of negotiation do you want? Do you want a positional negotiation where people are going to argue about who is right and who is wrong? Or do you want people to really engage in a genuine dialogue, visit one another's planets, and be able to look at the conflict more holistically? And that is a very important distinction, because what I believe that makes the full difference in mediation is getting genuine dialogue in place, as opposed to a positional monologue between lawyers on both sides. And so let's think about process design and what it does to encourage one form of negotiation over another. Here is litigation or arbitration as we know it. We've got party one, we have party two, they fight, the tribunal decides everything. And we basically only look at the tip of the iceberg, the rules of law and the facts that are relevant to the case. And that's how we decided. That's the very bottom of the spectrum I was showing to you. And it works, and that's what's used today, but not well. It's too expensive, it takes too long, and also relationships tend to get destroyed, partly because of this process. Let's now focus on conciliation. Conciliation looks at first more like arbitration. You have two parties, you have a conciliator who's an expert in the field, and based on their knowledge of the field, the conciliator can look at the precedents, look at the laws, look at the doctrine, the textbooks, what they say, look at what's relevant as opposed to irrelevant, understand the parties' positions and analyze them, and with that, provide a zone of possible agreement based on the norms of their understanding of the situation and the case. And so we're already using a legalistic way of thinking here. And what we are doing is we are trying to say, settle in this zone, and if you can't, the conciliator will make a proposal. It's sometimes referred to as a mediator's proposal, but that's really confusing mediation and conciliation. What is happening in the eyes of most people is they think that the mediator should be a conciliator who should be making a proposal. And basically, if they want to accept it, they can. And if they don't need to. But at the end of the day, many countries teach mediation that way, where you start off as a facilitative mediator at 9 o'clock in the morning, but by 9 o'clock at night, you need to be more evaluative and you need to be able to make a proposal if they wanted to settle. But that's also because you are conditioning your view of mediation as a one-day process. And so I think we need to really separate conciliation, this approach you see here, which is about a so-called objective way of applying justice still, using the norms of law, to mediation as I understand it. So here's my understanding of mediation. You have the mediator and the parties, but it's just a facilitated negotiation. There is no zone of possible agreement. There are no proposals. A mediator should not make a proposal unless both parties wish to and ask for it at the same time. It's not up, I think, to the mediator just to suggest, now's the time, I think this would help, let me make a proposal. Because the moment the mediator starts to make a proposal, in a way you rob the parties of the ability to really resolve it themselves and to dig deeper into why are they taking these positions and what are their future needs and interests. So The Swiss approach is a mediator should not make a proposal. There should be no zone of possible agreement based on norms. It's all about subjective needs and interests. And there's nothing that is irrelevant. You look at everything in the iceberg. And while the law is relevant, it's only a benchmark for the outcome you've negotiated. Because if you can do better in court than what you've negotiated, maybe continue with trial. But normally mediations go way beyond the remit of what is within the scope or not of the law. Let me give you a good example. I had a patent case in the beginning. This is one of my first cases going back around 20 years ago. I walked into a room, this was a fight about patents, and there was prior art, and people were fighting about, is the patent valid or invalid? At the end, in the room, there were executives on both sides. And basically, I thought, I can continue as a lawyer. I was not mediating the case. I was a lawyer in the case. We were negotiating. We did not have a mediator present. But I basically thought, let me try a mediative approach to this negotiation because it's not going anywhere. And I asked the question, could we just talk about our needs and interests for a moment? Let's set aside the patents. Let's talk about the industry. Let's talk about what is needed in our industry. Do we have a common view of the future? And if so, what is that common view of the future? It turned out this was a case in the diagnostic field, that the two companies had a very unique and very complementary understanding of the future in the industry. When they understood the technologies and how they were looking at the future, a joint venture became a very natural topic for discussion. And a joint venture actually resulted from that mediation. We stopped talking about the patent. We stopped talking about the prior art. The value of what was discussed was far greater than the question of the patent, with all of its risks of who might win in one country or lose in another. That is where I think the strength and the interest of mediation lies, which is why I do not think it is useful to bring an expert with subject matter expertise that is legal. Knowledge about the industry is more important. And so I would invite you to think of mediation more in terms of what sort of subjective justice can we have, rather than this belief that there is such a thing as objective justice, especially when it comes to IP disputes. So that is an overall invitation for you to think about this. Now, let's just talk about it. And I see time is running out, and I think I have only 1 minute left. And so...
Jeremy, дуже прошу, буквально 1 хвилина.
Yes, Jeremy, if you could wrap up within 1 minute, because we need to pass on to our moderator.
I saw the time. That's why I'm wrapping up. And so just to summarize, it is far cheaper. There are statistics about this. You will see that it's roughly less than 5% on average to mediate a dispute of the value of the dispute compared to arbitration or going to court. And also when it comes to settlement rates, we heard WIPO's impressive 70% rate. Actually, WIPO's rate has gone above 78% when you use their online case administration tools, but using other centers as well works just as well. And the average is between 70 to 80%. It's faster, it's cheaper, and it is better. I'm going to stop at this stage. I'm just going to let you know there are ways of designing customized disputes to reach faster, better, cheaper outcomes. There's even a way to finance this. If you're having difficulty with a case and getting the financing for it, there are funds now that will finance and pay for the design of an amicable dispute resolution process, not arbitration, but mediation, using maybe a mixed mode, maybe bringing in experts, but everything is now possible. And I just wanted to basically summarize by saying, please think of mediation differently. Think of it as something faster, cheaper, better. The question is not when to mediate. The question is when not to try to mediate. Because if it's faster, if it's cheaper, if it's better, and you will get more than 80% probability of settling, then why would you not use it? And I think that is the new question we need to be asking ourselves. So I'm going to stop for that for today. Thank you very much for your time, and I'm happy to answer any questions. And there's also an article and some information and a more full deck of slides that you can find online. Thank you.
Дорогі Джеремі, дуже дякуємо за ваш
Dear
виступ.
Jeremy, thank you very much for your presentation. All the materials are shared with all the participants, so everybody will have access to them at a later stage. So now it is my pleasure to give the floor to Bogdana Klemenko. She's a mediator, attorney at law. She tries to foster and promote mediation here at the national level. Bogdana, please, the floor is yours. Don't worry, we're going to give you 10 minutes of time so that you can make your presentation.
Доброго дня, чутно мене?
Good morning, good afternoon. Can you hear me? Yep. Yep.
Супер. Я постараюсь
Super.
швиденько.
I'm going to try to be fast. All in all, I wanted to tell you a bit about some of the distinctive features and my observations about mediation in Ukraine, especially pertaining to intellectual property disputes.
Перш за все, кілька слів про мене.
First of all, a couple of words about myself. I've been a lawyer since 2014. I've been resolving disputes for quite a while. And also I've been doing consultancy. What's consultancy special in Ukraine?
Простого вирішення спору
We
не було.
didn't have this mediation practice before as one of the options. But lawyers are always eager to help. However, there are still limitations by the law which we cannot influence anyhow. But when talking about intellectual property in this sector, there are so many limitations and reservations in the field. And that's probably an entry point for the mediators, because lawyers may not help sometimes, and those disputes can sometimes be resolved through mediation. Why Ukrainian mediation is special is that very few people know about it in Ukraine. And when we're talking about the European statistic, then in Europe, around 83% of people in the EU are aware. Oh, sorry, 83% do not know about mediation. In Ukraine, the statistics is even worse than that. Altogether, if we analyze Google Trends, you can see demand for mediation in Ukraine is growing, but not as fast as we wanted to. Just around a couple of hundred of applications we receive every year, and unfortunately, our clients are not looking for this solution sometimes. So we have to be proactive and find ways how to explain what mediation is and what it isn't, and how to promote it. Just a couple of words about the Ukraine's IP mediation office. We've been doing an incredible job lately. Ulrika has already told you a bit about it. We try to promote mediation across those areas where legislation cannot affect the situation. Therefore, people can always go to our office whenever they have a conflict and with the intent to resolve it. I want to tell you about other cases which are not covered by our legislation, I mean domestic legislation. We all know that intellectual property rights are special because they are generated almost every second. And in most cases, they're not getting registered properly. So in any case, the whole issue is that most of them are not anyhow regulated. That's why lawyers are limited in this sector. The first rule in IPR is it first come, first served. You come first, you get it. An interesting case regarding this principle can be observed. It took place several years ago between the Golden Age, this is a jewelry producer in Ukraine, and a smaller manufacturer of jewelry, Guzima. But the Golden Age is a mass manufacturer, but Guzima is rather a small one, a local one, and it costs much more expensive. Normally, their produce costs much more expensive than that of the mass manufacturer. When Guzima actually produced a ring, they realized that the Golden Age started selling similar, if not identical, products. The situation was that Guzima, given they had patent for it, and as also the industrial design, it was found that the Golden Age had been producing it earlier than them. They had to produce evidence that they were the first ones to have manufactured these items, even before Guzima was patented. And then they decided to litigate. Happily, the conflict was resolved. I don't know whether the mediator was involved or not, but there was a conciliation agreement. I had a similar case as well.
виробник дизайнерських меблів
But it
побачив,
was
що
about that a
його
designer furniture manufacturer
продавалися в
has seen some of the copies of his furniture manufactured by a mass producer. So what happened in that particular case is that the design furniture, individual design furniture manufacturer provided evidence that their furniture was initially produced by themselves because they were prize winners of many international competitions, and they were also published in so many different magazines. That was the reason for the other side to understand that, okay, fine, we understand, we do not have the right, this is your copyright, and they decided to go for conciliation. Regarding trademarks, we're all aware that trademarks are very important because they generate added value. In these pictures, you can see the Balenciaga bag costs $1,600, while a similar bag in Ukraine without trademark only costs less than $4. The trademarks regulation in Ukraine is special because the majority of businesses never register them. For a small business, this can be a lengthy and costly procedure. That's why they don't pursue it, especially at the beginning of their business. This is why we have so many disputes where the trademark issues cannot be settled, only referring to registers. Co-authorship, this is another point which in the Ukrainian law is very well described, but unfortunately is so far away from the real situation, because according to the Ukrainian legislation, transfer of the copyright has to be done in writing. And if there's this co-authorship taking place, then in fact, this copyright covers both. In most cases, nobody has any written agreements, like for photo sessions, when the right for the product belongs not only to the photographer, but also to the fashion model and visage specialists. Unfortunately, the regulations are very much different in Ukraine versus other countries. That's why there is a great potential for mediation here in this sector. There's another issue that service contracts and employment contracts, according to the Ukrainian legislation, unless otherwise provided otherwise, then the service contract party, this is like a co-ownership of the property rights. So normally, unless this is a written agreement or part of it, this can be the reason for both parties to complain and apply for remedy. So mediation here has great prospects as well. Regarding ideas, as we know, they're not copyrighted. But in business, ideas play a great role. I have one of the pending partnership agreement where part of the obligations of one of the parties was to generate ideas. That's important, especially in creative industries. So despite the law does not regulate it anyhow, we as mediators can give an opportunity to reconcile. Also regarding texts, it's very difficult to regulate texts unless there is a direct copy-pasting case proven. Then there is a fine line between getting inspired by the text or stealing it. Very often, legislation or courts spend so much time and effort and money to try to settle those conflicts that in fact can be resolved through mediation in a much cheaper manner. And there is one more thing which is existent in the Ukrainian legislation. For instance, a training course, methodology, or a curriculum, they are very poorly protected. They are protected like literature. But whenever we talk about literature, it is difficult to say whether it was a copy-paste case or anything, like plagiarism. Those people who design online or offline courses or their own methodologies, they're vulnerable against the legislation, but they can be protected through mediation, of course. This is probably it from my side because we ran out of time. Thank you so much, Bogdana. I want to thank you so much for making it within 10 minutes. We do apologize for forcing you to shorten your presentation. I want to thank all our speakers.
Особлива подяка Джеремі,
And
який
special thanks
уже
goes to
підготував
Jeremy because
питання до всіх
he
спікерів в
was trying
чаті.
to answer so many questions in the
Я
chat.
хочу передати
So let
слово
me
пані
hand over the
Луїзі.
floor to
Ми
Louisa.
вибилися із графіку
We're just out of time. I'm sorry, I understand that. But today we have great stars. I mean, the speakers, and it's so difficult to limit their presentation, so I couldn't actually intervene and stop them.
Розумію, що далі в нас іде наступна панель форуму.
We're going to have another panel discussion in just 4 minutes. So all those questions that you typed in the chat, we're going to ask our speakers to please answer them when possible. And we will let you guys know about the answers. Our communication will continue. Now, Louisa, if you are with us, please tell us what we're supposed to do next. Over to you. Thank you so much again. Many thanks, Oleksandra, for your remarkable moderation. You tried to keep as much balance as possible given the short time we had. And you tried to get as much information from the speakers as possible. I want to express my sincere gratitude to every speaker today who have made their presentations. I believe this panel has been a very strong one. We managed to take a 4-dimensional view at the moderation's capacity, and we managed to learn about the regulatory frameworks and opportunities they provide based on WIPO's experience and EU IPO and the Ukrainian IP office. We want to thank Oleksandra for delivering that information that we requested initially. Thank you so much. And I feel so sorry that we don't have enough time to answer all the questions, but please, I would encourage speakers, when possible, to please provide answers to our audience. We will encourage our participants to also ask more questions if they have them. We will put them all together, share them with you. You can answer, and then we're going to create a dedicated chapter on our website. So after the forum, we will have all the recordings, all the questions, all the materials. We're going to have a section dedicated to this forum with answers to the questions, if you don't mind. If so, then I would encourage our audience to think of more questions, and maybe our speakers will do this post-reflection, so to say. Let us show the full screen, the gallery view, and then we're going to try to figure out if we can take a family picture. I can see Jeremy, thank you. I understand. If everybody's quiet, that means everybody agrees. Okay, then please share more questions in the chat. We extremely thank all our speakers, but there's another thing, like I said, I want to say a lot of thanks to our Ukrainian IP office for what you've been doing, for all those initiatives, for all the cooperation. Despite the war, this is just horrible what's going on right now in Ukraine. We sometimes have blackouts and we don't have electricity for dozens of hours sometimes. There's no connectivity, nothing. But you still keep working and launch so many different initiatives, even ahead of time sometimes. I'm sure some of the offices can borrow your best practices with your contingencies and everything. And in view of this one, I'd like to make another announcement. I already announced this yesterday about our 10th anniversary of the Ukraine's Mediation Academy. We introduced an award for the Ukrainian organizations, those not only non-governmental, but also government organizations that contribute to the development of mediation in Ukraine. This award is called Mediation Partner, and we have a dedicated page specifically for this award, and there is already information published there that our Ukrainian IP office is our great partner. You are now getting our award, so congratulations, and thank you for contributing to mediation in Ukraine a lot. to its development. There is another partner who is awarded. I'm just trying to be real quick. While we're having fun and discussing all this professional information, there are people who continue doing the job behind the curtains, so to say. You know, there is Pablo here. He is trying to moderate the forum of the legal newspaper. We have one of the organizations which is called the legal newspaper. They invest so much effort and time into promoting mediation, and they are our rewarded partners. So we've been doing so many different activities together, and we run information campaigns through this newspaper. I was trying to be real quick, and now just a brief announcement. Let us please take 5 minutes break. I do apologize. Please, dear speakers, for the next panel, because we have so many technical supports and interpreters as well. They need to have a bit of stretch possibility. Then after the next panel, we're going to have 3 hours for a break. So now let's take a 10-minute break, and then we're going to reconvene. So please, all those who enable this forum, please, you can stand up and stretch, have some water, coffee, or whatever you have normally. And let us please take a family picture like we did yesterday. This is a brief instruction. Right now, we're going to take just a screenshot. If you can, please turn on the gallery view and turn on your cameras.
І зробимо тоді фото, як ми робили вчора, тобто
like we did yesterday and the day before.
Ми контролюємо
It's like in mediation. Everybody is control of him or herself. So
контролює, в який момент його сфотографувати. І перед тим, як після того, як ви там зможете посміхнутися, там
you smile
дивитися,
and comb your hair.
просто натискаєте allow.
Just press allow. That means you give your consent for the picture. Thank you.
Фотографії потім так само можна буде знайти.
The pictures will also be available on our website.
Все в одному місці.
So this is a one-stop place where you can find everything. I want to thank our speakers once again of this extremely important first panel. Bogdana, Marisol, Oleksandra, Jeremy, Isha. Thank you so much, everyone, because this was incredible. And it's been so interesting to hear all that information. And thanks, Oleksandra, for setting the tone for this discussion.
До зустрічі на наступних панелях.
See you next time in the other panel discussions. Please stay with us. We have many more to come. And we're working also tomorrow with so many fancy activities. Okay, you can now take a break. Just stay connected. Don't leave. And I will make a couple of more announcements. I can see Oksana Yerenko in the chat shared a message. I'm just going to be talking to you during these 10 minutes. You please have fun. Interpreters continue to work because there are more announcements coming. So I'm going to be sharing a bit more information with you. Oksana, I can see your message. If all of a sudden you haven't seen it, but your university is one of those institutions that has been rewarded by our Mediation Partner Award. Let me share this on the screen. Because those who normally speak here when we announce them, but we do not announce those who are working here. You can see all this information on the website. You can see all our award winners. So now, this is it. Yesterday, I was telling you a bit about the whole idea behind this award. The idea is that we want to appreciate contributions from government agencies, civil society organizations, and businesses who contribute to mediation developments in Ukraine. Contributions can be different. Yesterday and today, we were talking about the importance of communication. and awareness raising. So there are so many different ingredients here. So if you do something in one of these 4 domains, you can absolutely easily get nominated, or you can also nominate another organization. This must be a legal entity. There are 4 categories. Raising awareness on mediation, about mediation, like the legal newspaper, we mentioned it today. Also those that provide access to mediation, for instance, the Legal Aid Coordination Center, or those who apply mediation in their business, and they really promote it as one of the tools for dispute resolution. Yesterday, we were mentioning one of the legal firms, and those who contribute to the development of mediation in general, overall in Ukraine. And those are our government agencies that are getting involved. This is the Ministry of Justice, Ministry of Social Policies, and of course, our parliament that adopts so many different statutes, and specifically its subject matter committee on legal policies.
The only person who cannot be recognized are the mediators themselves. Therefore, they cannot get this distinction, but everyone else can. It could be courts, it could be communities, it could be anyone really, any legal person who is promoting mediation. Now, how do you get this distinction? Well, it's quite easy. You simply take simple steps. You click on nominate button, and you can nominate yourself and present this information. Because of course we can't see everything, we can't know everything. You can also nominate anyone else with whom you interact, for example. Could be an association of mediators, for example, some other organization or university. Incidentally, all the pilot universities are partners with whom we opened mediation services this year. They have already received this recognition, and first and foremost, the ones with whom we work together and where we have accumulated some joint experience. So this is the information for you. Here's the list. Here, if you search, you could perhaps find either yourself or one of your partners and see that you've been recognized. In the future, we, of course, will keep you up to date about the latest awards after this forum. Another important piece of information is this is not our initiative, but it's an important initiative, in my opinion. Perhaps not everyone is aware of this, but yesterday many people were saying that we need to think globally about the processes, something that should unite mediators across the globe. And one of such ideas to unite is to do with, the fact that in our mediation activities, we need to also be mindful of environment and the negative consequences that might lead to the environmental damage. There is a simple way of learning about this. You can make certain commitments and then you can sign your commitment. Here's the list of signatories, and you can take this green pledge, and what this is about, and what it might look like in the future. So first, you agree to certain terms and conditions. Then you can use this logo, Mediator's Green Pledge, which will signify the fact that you care about environment and you undertake to use less things that have negative impact. For instance, you do more online than offline. For instance, you fly with airlines less, and in doing so, you pollute the air less. Small things, like use less paper and use electronic media. And thus reducing the environmental impact and reducing your carbon footprint. Ukrainian mediators, by the way, in Ukraine are mostly online. Most trainings are done online. Apart from the military jets, unfortunately, no civilian airlines fly to Ukraine. So wherever we need to go, abroad, for instance, we have to use a bus, a car, train, whatever, but not the airplanes. This concerns, of course, equally Ukrainian and foreign mediators. Well, at this stage, I think these are all the announcements that I wanted to share with you between our sessions.